Our democracy was created by people and for the people. When government power is used to target Americans for exercising their constitutional rights, there is nothing we as representatives should find more important than to take it seriously, get to the bottom of it, and eradicate
non-partisan manner. When the IRS breaches that trust, it damages the ability of the agency to implement the nation's tax laws effectively and efficiently.
Unfair treatment by the IRS. The three allegations considered during our review were proven true. The IRS targeted specific groups applying for tax-exempt status. It delayed the processing of these groups' applications and requested unnecessary information, as well as subjected these groups to special scrutiny.
Since 2010, there appears to have been a targeting of people based on their beliefs. These people, particularly those who use Tea Party in their name, were mocked by the liberal media, mocked by late-night television, and referred to by this administration regularly with disdain.
Report.
Even here in the House of Congress.
I was dismayed and saddened to read the Inspector General's conclusions that actions had been taken creating the appearance that the service was not acting as it should have, that is, as a non-political, nonpartisan agency. Utilizing a list with keywords to select applicants for review based on organizations' names or policy positions is, in my view, inappropriate and damaging.
And use other forms of intimidation. In my view, these and other blatant violations of individual freedom of expression serve to illustrate exactly what is at stake when a federal agency, for whatever reason, targets U.S. citizens based on their political beliefs. Such a practice compromises one of the bedrock principles of our democracy, the commitment to ensure that all citizens are free to exercise their freedom of speech without fear of retribution from their government. And it constitutes a significant infringement on human rights in this country.
Vast.
It is why the fact
because
that
every single person who looked at one of these applications could have and should have been a whistleblower, could have and should have realized there was something wrong.
Identify tax-exempt applications.
During this,
like President and Secretary Liu, I believe that the activities described in the report are absolutely unacceptable and inexcusable. The IRS must operate without bias or even the perception of bias. It must act in an utterly nonpartisan manner. It must act with the utmost integrity.
And the bottom, unfortunately, is that this is not the first time that this has happened. Focusing on groups because of their political beliefs was wrong when the IRS did it to Greenpeace. It is wrong when the IRS did it to the NAACP. And it's wrong now when they've done it to these 501c4 applicants. Regardless of which party holds power, this behavior has to stop.
All live in.
What I'd like to focus on.
It also raises the question as to whether or not America's institutions are failing the American people that they serve. This was a failure by the IRS, whichever conclusion the facts lead us to. Just the conduct that raises legitimate questions as to whether or not there's been selective enforcement and politically motivated action compromises the ability of that institution, the Internal Revenue Service, to have credibility to do the job that the law requires it to do.
something just didn't seem to be right. What we didn't know what was really wrong, and we could never have suspected an organized and pervasive denying of hundreds of applications, not by a reject stamped and sent back, but by deliberate inaction.
Is out to get
so our
them.
suspicions.
And when things like were going on, you had a battle of titans. You had the politically powerful going after the politically powerful. But in this matter, you have the politically empowered going after the people who hired them and people who don't have the weapons of the imprimatur of the federal government to turn to.
about Ms. Lerner. Her attorney has written to the committee to inform us that she intends to invoke her Fifth Amendment right against self-incrimination. Of course, I am disappointed that we will not be able to ask her questions today. I believe that she could shed much light on what we are trying to find, the truth. But every member of this committee takes an oath to support the Constitution of the United States of America. And this is Ms. Lerner's right under the Constitution. So I will honor her decision, and I respectfully urge all of my colleagues to do the same. I want this committee to be very careful, and I've said it many times. This committee should act on the level of a federal court. And I think we need to be very, very careful not to let partisanship undermine the integrity.
Launched an investigation into the matters described in the Inspector General's report. In addition, members of this committee have accused me of providing false information when I responded to questions about the IRS processing of applications for tax exemption. I have not done anything wrong. I have not broken any laws. I have not violated any IRS rules or regulations, and I have not provided false information to this or any other congressional committee. And while I would very much like to answer the committee's questions today, I've been advised by my counsel to assert my constitutional right not to testify or answer questions related to the subject matter of this hearing. After very careful consideration, I've decided to follow my counsel's advice and not testify or answer any of the questions today. Because I'm asserting my right not to testify, I know that some people will assume that I've done something wrong. I have not. One of the basic functions of the Fifth Amendment is to protect innocent individuals, and that is the protection I'm invoking today. Thank you.
Thank you for your testimony. As far as your recollection, that is your response.
That's correct.
Ms. Lerner, the topic of today's hearing is the IRS improper targeting of certain groups for additional scrutiny regarding their application for tax-exempt status. As Director of Exempt Organizations of the Tax-Exempt and Government Entities Division of the IRS, you are uniquely positioned to provide testimony to help this committee better understand how and why the IRS targeted these groups. To that end, I must ask you to reconsider, particularly in light of the fact that you have given not once but twice testimony before this committee under oath this morning. You have made an opening statement in which you made assertions of your innocence, assertions you did nothing wrong, assertions you broke no laws or rules. Additionally, you have authenticated earlier answers to the IG. At this point, I believe you have not asserted your rights, but in fact have effectively waived your rights. Would you please seek counsel for further guidance on this matter while we wait?
I will not answer any questions or testify about the subject matter of this committee's meeting.
We will take your refusal as a refusal to testify. The witness and counsel are dismissed. The gentleman will state a point of order. Please wait.
Mr. Issa, Mr. Cummings just said we should run this like a courtroom, and I agree with him. She just testified. She just waived her Fifth Amendment right to privilege. You don't get to tell your side of the story and then not be subjected to cross-examination. That's not the way it works. She waived her right to Fifth Amendment privilege by issuing an opening statement. She ought to stand here and answer our questions.
Mr. Chairman.
Mr. Cummings.
With all respect for my good friend, Mr. Gowdy, I said I'd like to see it run like a federal court. Unfortunately, this is not a federal court, and she does have a right, and I think, and we have to adhere to that.
Thank you. Ms. Lerner, I'll ask you just a couple of additional questions. Is it possible that we could narrow the scope of questions and that there are some areas that you would be able to answer any questions on here today?
I will not answer any questions or testify today.
Ms. Lerner, would you be willing to answer questions specifically related to the earlier statements made under oath before this committee?
I decline to answer that question for the reasons I've already given.
For this reason, I have no choice but to excuse the witness, subject to recall after we seek specific counsel on the questions of whether or not the constitutional right of the Fifth Amendment has been properly waived. Notwithstanding that, and consultation with the Department of Justice as to whether or not limited or use immunity could be negotiated, the witness and counsel are dismissed. The clerk will please rearrange the seating. For all the members on both sides of the dais, I think it's important that we take a moment, both I think I speak for Mr. Cummings and myself. This is a committee that is investigating more than anything else the ultimate right of free speech and the First Amendment. So as we go on with the rest of this hearing, I would admonish all of us to remember that it's not the First Amendment or the Second Amendment or the Fifth Amendment or the 10th Amendment in a vacuum. We have to respect them all. The gentlelady who has departed was entitled to assert her Fifth Amendment, although there's some questions about how it was done. There can be no question that we have to respect it. Additionally, that her assertion is not to be viewed or used during this hearing to make any determination plus or minus as to actions that were taken. We have the Inspector General with us today.
I just want to say the same. I appreciate what the Chairman said. I think he's right on target, but the irony is inescapable. Ms. Lerner gets to exercise her constitutional rights, but she won't stay here and answer questions about the constitutional rights of thousands of Americans who were denied by their
It is important to note that the IRS conducted an audit, that we, TIGTA, conducted an audit of the IRS and not an investigation. Pursuant to the Inspector General Act, TIGTA is authorized to conduct both audits as well as investigations in our oversight of IRS programs and operations. Audits are generally reviews of IRS programs designed to identify systemic problems and recommend corrective actions, whereas investigations are focused on a person or persons and are usually undertaken in response to reports or complaints of misconduct. Investigations may be criminal or administrative in nature and can result in referral for prosecution or referral for management for administrative action.
Servants. While the Inspector General's report did not indicate that there was any political motivation involved, the actions outlined in the report have justifiably led to questions about the fairness of the approach taken here. The effect is bad for the agency and bad for the American taxpayer. I'm happy to answer questions.
Thank you.
Opportunity to appear before you today. Last week, the Treasury Inspector General for Tax Administration, Mr. George, published a report on the Internal Revenue Service's use of inappropriate criteria to identify tax-exempt applications. Like President Obama and Secretary Lew, I believe that the activities described in the report are absolutely unacceptable and inexcusable. The IRS must operate without bias or even the perception of bias. It must act in an utterly nonpartisan manner. It must
et cetera. So essentially, this began in your mind when you were made aware of it in March of 2012 by members of my committee, staff members of my committee, correct?
Yes.
So,
Mr. Chairman, there are established procedures for conducting an audit, and once again, this is an audit. And to ensure fairness and to ensure that we are completely accurate with the information that we convey to Congress, we will not report information until the IRS has had an opportunity to take a look at it to ensure that we're not misstating facts.
Mr. George, that is not.
In your review of the situation, have you identified in Cincinnati the individuals who have developed this BOLO list?
We have not yet, ma'am.
And why not?
We have had some difficulty in terms of getting clarity from some of the IRS employees we've interviewed. Keep in mind, this is an audit. The people we have been interacting with were not under oath. And so if this matter develops further and changes its character, that might change the willingness of people to be more forthcoming with the information.
To the effect that from your looking into this matter, whether you call it an audit or an investigation, from your looking into this matter, you saw no evidence that IRS employees were politically motivated in their creation or use of the inappropriate screening criteria. Was that essentially your testimony?
That we received no evidence during the course of our audit to that effect, yes, sir.
All right, so.
Thank you. I think that makes it. One more thing. There were 479 or so of these Tea Party groups that were targeted in total. Were there any BOLOs issued for progressive groups, liberal groups? Because I'm assuming that your investigation, we can't see them, but your investigation showed liberal groups that flew right through during the same time and got their 501c4s. They were not stopped. Isn't that correct?
Sir, this is a very important question. Please, I beg your indulgence.
Of course.
The only be on the lookout, that is BOLO, used to refer cases for political review were the ones that we described within our report. There were other BOLOs used for other purposes. For example, there were lookouts for indicators of known fraud schemes, so they could be referred to the group that handles those issues. For nationwide organizations, there were notes to refer state and local chapters to the same reviewers. As we continue our review of this matter, we have recently identified some other BOLOs that raise concerns about political factors. I can't get into more detail at this time as to the information that is there because it's still incomplete, that we've uncovered because it's still incomplete. And there are 6103 issues involved here, too.
So clearly it's fair to say, though, that
management.
No, staff and management, both. When you say IRS personnel have not been completely forthcoming on some of the issues you've asked about.
That is an inference that can be made from the fact that we have not gotten clear answers.
So that's what I'm trying to ask is staff, management, so two different levels of individuals, you're not getting completely full answers that you expect when you ask them.
While I am not in those interviews personally, sir, that is my understanding.
Okay.
Mr. Woolen. Appropriate.
Okay. Mr. George, your report indicated that after Ms. Lerner discovered the IRS employees in Cincinnati were using inappropriate criteria, she stopped them immediately. Is that correct?
That's, well, I don't know how you define immediately, but she did halt that behavior, yes.
Thank you. But then the employees started using slightly different but still inappropriate practices a few months later?
Correct.
Okay. How were these employees allowed to resume these activities after management stopped them the first time?
That is the heart of the question, Congresswoman, which we still do not have a definitive answer to. My response, if at this stage, would be a lack of oversight, a lack of follow-up on the part of Ms. Lerner and people within her immediate chain of command. No one went back to make sure that what was.
You may not be able to speak to intervention that came from above or any other place, but you can't rule out that there was some at some time.
That is correct, sir.
Thank you. We now go to the gentlelady from.
Thank you. You testified yesterday that in conducting the audit, your office did not give further review to any of the more than 200 501c4 applications in your statistical sample and did not have Tea Party, 912, or Patriots in their title. Is that correct?
We looked, sir, I beg your indulgence. 202 non-Tea Party cases, so the various groups that you just enumerated, were reviewed for indications of significant political campaign intervention, which was our key criteria, again, in this exercise, in this review, Congressman. We did not evaluate whether or not they were conservative groups or progressive groups or liberal groups or whatever term you want to use, because those groups did not, again, have the be on the lookout terms, Tea Party, Patriot, or 9/12 in their names. But
important, Mr. Wolin. You keep saying, and Mr. Shulman kept saying, that by the time you learned about it, the offending activity had finished. The offending activity is two parts. It's the abusive behavior of questions, inappropriate questions, questions that are probative that in fact make us doubt whether or not that information leaked. Let's leave that aside. I think the IG has determined a cutoff date. But are you here today to tell us that no entity has been denied approval or denial in a timely fashion? Because I believe Mr. George will testify that as far as he knows, people are still in limbo today.
No,
on your watch.
Not at all, Mr. Chairman. I think you're exactly right. The IG has made that clear. Now that we know that, we learned that last week, this needs to be fixed quickly, absolutely, and that's part of the charge that Mr. Werfel has.
I'm holding in my hand as well a questionnaire, one of the organizations that made an application, but their application was made in 2009. It's now 2013, and they still have not gotten a response. And yet here we are, 39 questions that are being asked. This is the second level of questioning.
Informed by staff that the is 121 days for the processing of these, but unfortunately, they've averaged over 574 days.
So when they get behind, do supervisors get noticed?
But the IG discussed also how some cases took more than 3 years to resolve. Ladies and gentlemen, we're better than that. We are simply better than that.
The technical unit is located in Washington, and as I discussed much earlier at this hearing, the technical unit took an inordinate amount of time to respond to many of the requests from the
5 years, for 4.5 for this applicant.
But, sir, but it's very important for me to point
George, I want to clarify several things. One of them, you made the comment that so far none of them have been turned down. They just had this inordinately large amount of paperwork and additional questions applied to them, and it's a long delay with no response, and it's basically we'll get back to you at some point. Is that correct?
That is correct, sir.
Man, that sounds like the Keystone Pipeline to me.
Thank you. Just to clarify what the gentleman was asking, none were denied, but by definition, not granting them is in fact not allowing them to happen. So you can actually deny better by not denying, because if you deny, they have a right of appeal. If you just let them sit in limbo, they're screwed, and some are still screwed today. Isn't that correct?
That's
a term of art.
Yeah, I was going to say I wouldn't use necessarily.
But if you were a Tea Party organization, you'd use that term.
I would be very frustrated, sir.
Right.
Yes.
Two quick things to clarify, because the gentleman made a very good point. You did talk about the complexity about the system, but in no way did you say that this misconduct was the result of a lack of clarity. In other words, targeting these individuals is not because of complexity, but rather something that was inappropriate, whether it was complex or simple.
It's a combination, Mr. Chairman. The determinations unit did have some technical questions, which they submitted along the chain to the appropriate people in Washington. It took over 13 months before they received a response. That was a cause of some of the delay in addressing some of the exempt issues. But I would attribute it mostly to a lack of training, sir, that there was very inadequate training of the people who were handling these applications. And I do fault the IRS
days now that it's been years.
Well, I don't want to speak for Mr. Werfel in setting a precise timeline, Mr. Chairman, but it is clear.
You're his boss. You speak from the President to the Secretary to yourself to him. What the heck appropriate timeline should we expect when you've been drowning these people for 3 years or more in some cases? What is the timeline today? If you're not accountable today, then you're not ever accountable. Could you give us a timeline? In your opinion, what would be the maximum time somebody should have to wait when they've waited for years?
Well, as I've said, Mr. Chairman, what we've charged Mr. Werfel with is coming back within 30 days and to fully and promptly implement the various recommendations in the IG's report, of which this is one.
Moreover, the audit report notes that the same determination units sent out burdensome request letters for additional information, 58% of which the Inspector General has characterized as unnecessary. In light of these and other reports,
substantial delays in the processing of their applications. In addition, many of these organizations received requests for unnecessary information, including lists of donors. In closing, our overall assessment.
Let me ask you this. Apparently, one of these groups called the Coalition for Life was asked was asked by IRS officials about prayer meetings that they had held and how much of their time was spent on prayer meetings and what went on at those prayer meetings. Do you think that questioning like that is proper?
No, Congressman. I think that the conduct that is outlined in the IG's report is obviously inexcusable, deplorable. I can't be more clear than that. It's absolutely outrageous.
Mr. Shulman, do you think that those types of questions should be asked in this situation?
Certainly sounds inappropriate to me.
About religious beliefs.
No, I don't. It sounds inappropriate to me.
Now, a few minutes ago,
office in response back from Steve Miller. In that response that I got back from Steve Miller about this exact issue, he said in those cases where the application raises issues for which there's no established published precedent, I assume that's the Tea Party groups and everything else, or no uniformity, EO determinations may refer the application to EO technical. EO technical, the applications are reviewed by tax law specialists whose job it is to interpret and provide guidance on the law and to work closely with IRS chief counsel attorneys on the issues. That's a lot of folks when there's new ground to be broken. Now, from my district, this is one of those letters that came in from someone in my district that specifically contacted me and had a whole series of questions that came back to them with what is in my area, the Oklahoma City Patriots in Action Group. They were asked questions such as, have any candidates running for public office spoken, or will they speak at your function or organization? If so, include a transcript of any speeches given by candidates, which is remarkable to be able to ask. Do you directly or indirectly communicate with members of legislative bodies? And there's no definition for what indirect communication is given on that. It's just, have you had, I don't even know what that would mean. My favorite question, who developed the website and has control over the data generated by the website? Not only is that an insane question to ask, it's not even grammatically correct. 19A, provide all copies of your corporate minutes from inception to the present. This was asked, and at the beginning of the first page it says, under penalty of perjury, I declare that I've examined this information, and goes through in this long statement. My issue is this is new ground. And based on the letter that we received when I wrote the letter to you, it lists a long list of people that have to be involved in the formation of this. How do we get the list of individuals that were involved, or at least the process of how these questions were done? Because this assumption that this is a couple rogue agents does not match up with the letter and how we were told this was actually created. This includes technical folks, attorneys, chief counsel, EO. This is a pretty large list of people that are involved in creating this. Someone knew, in fact, a lot of someone's knew about this, because you can't form this without this. How do we get that information? Mrs. Lerner is obviously the best person to ask. She's chosen not to answer questions. How do we get that?
Look, as you said, there's probably other people who work on the details of that who you could ask. I would presume you ask it directly. I'd presume that the IG, who now has a better understanding of this, would be able to be helpful. And I would presume that the committee investigative staff will take letters like that in your questions and ask, who was involved.
Oklahoma, because I'm standing and holding in my hand as well a questionnaire for one of the organizations that made an application. But their application was made in 2009. It's now 2013, and they still have not gotten a response. And yet here we are, 39 questions that are being asked. This is the second level of questioning. Now, we hear some of this. This is all being done for efficiency purposes and other kinds of things, and yet we have people that have 39 questions that they're asking on subsequent organizations. So the issue I have for you,
to some of these groups included a request for their list of donors. Do we know what happened to those list of donors? Do we have any insurance that, or assurances that those lists weren't made public, or somebody snapped a picture with their cell phone and sent it to an opposing group or a political candidate or somebody?
Very good question, Congressman. We were told by the IRS, the office that collected this information, that they did destroy the information. However, again, they were not under oath. We weren't there when it happened, but we have to take them at their word.
Yes, but
But right now, we're seeing an awful lot leaking out of the administration, and the IRS leaked in this particular case. This organization maliciously leaked this information. Mr. Williams.
If this is an event in which Ms. Lerner gave a speech and responded to a question.
A planted question, yeah. We now know. So she created a press release by planting a question which she was prepared to answer, and there appears to be an audit trail of that plan.
I had
absolutely work. I understand that from your staff that your office was not particularly happy about the way Lois Lerner at the IRS essentially tried to get out ahead of your audit. She basically orchestrated a question and answer at a ABA meeting on Friday, May the 10th. In your experience, have you ever seen an IRS official do something like that, or was that a first?
It was a first during my tenure, Mr. Clay.
But just to play devil's advocate, you had already briefed them on your findings, so what was the problem with them going public before the report was final?
They're privy to all of the information that we find because they have, again, access to information under the tax code, Title 26 for the most part. But there is a provision within the tax code, again, Section 6103, which provides for potentially criminal results if you release information, sensitive return information is what they call it, but the bottom line is that it's taxpayer information without the approval of the taxpayer. Mm-hmm. And a lot of the reports that we issue, this report included, contain information that would have been violative of the law had it been prematurely released.
The last 10 seconds. Mr. Wool, yesterday, Mr. Liu said senior aides at the White House, the Treasury Department, and the IRS debated the best way to break this news. When Ms. Lerner gave the speech and you had the planted question, how you were going to spin this, how you were going to bring this forward, were you involved in those discussions on how this story was going to break to the American people?
No, I was not involved in those.
So you weren't one of the people at Treasury involved, even though it's your responsibility to oversee the IRS?
Congressman, there were, and I think there's been press reporting on this, conversations among folks in the Chief of Staff's office and among lawyers about these questions, and I was not directly involved in those conversations, no.
Who at Treasury was?
Well, I think, again, we'll work with you to get the names, Congressman, but it were people in the Chief of Staff's office.
Do you know how the name Celia Rhodey, she was the person who planted the question, you know how she was chosen and why she was chosen?
Congressman, I had no involvement, no knowledge of that until we learned about it probably together when there was testimony from Mr. Miller on that question. I have no knowledge of that.
Thank you.
Familiar with those publications? The news ProPublica? Yes. I'm familiar with the organization ProPublica. And it is my understanding, based on reports from that publication, that your office provided that publication with the applications that were still pending, which were confidential. Is that your understanding?
than my office. I saw news reports of issues around ProPublica that I remember, and I don't remember the time stamp. And again, my best recollection is when those news reports broke, that it was referred to the IG to look at.
So what contributed to the confidential pending applications making it through the internal review process and being provided to the publication?
I don't have any knowledge of the premise that it happened. I saw news reports.
Well, but it should have alerted you because, I mean, as a head person with these big things happening, you should have followed up. Beauty's in the detail. I've watched you all day. I want to go further. Are you aware that in July 2012, Senator Harry Reid claimed Mitt Romney hadn't paid taxes for the last 10 years and claimed to have the information supporting that? Are you aware of that? I'm sure you are.
I have a recollection of reading that in the paper.
Do you know how Mr. Reid obtained that information? Did you look into this?
I have no idea.
Doesn't that alarm you that all of a sudden this pertinent information comes up, you're the head of this agency, and you're not asking questions? Shame on you. Absolutely shame on you.
Thank you, Mr. Chairman. Mr. George, I want to ask you about a report that the IRS disclosed taxpayer information that it should not have. Section 6104A of the tax code allows public disclosure of an application for tax-exempt status only after an organization has been recognized by the IRS as exempt. Last November, ProPublica reported that they requested from the IRS applications for 67 different nonprofits. In response, the Cincinnati IRS office sent ProPublica applications or documentation for 31 groups. 9 of those applications were still pending and had not yet been approved, meaning they were not supposed to be made public. Mr. George, during the committee's transcribed interview with Ms. Paz, committee staff asked her how this happened, and she explained that an administrative employee in Cincinnati who was supposed to check each application to ensure that it had been approved before disclosing it had made a mistake. Ms. Paz also told us that when the IRS discovered this disclosure, they referred the matter to your office. Is that correct?
I cannot even acknowledge the existence of an investigation, Congresswoman, pursuant to Title 26, Section 6103 of the United States Code.
Okay, well, can I read to you what she told? Ms. Paz told our investigators that your office determined that this disclosure was inadvertent. And I will read about the IG's review, and I quote, "They found that there was no evidence that the employee had done it for any political reason, that there was no reason to believe that it was anything other than a mistake." Can you tell us, Mr. George, did you in fact find any evidence that this release was intentional or that it was motivated by any political considerations?
Notwithstanding the fact that the victim is in a position to disclose his or her or its status, Congresswoman, I'm not able to comment on it.
Okay. So you...
While the Inspector General's report did not indicate that there was any political motivation involved, the actions outlined in the report have justifiably led to questions about the fairness of the approach taken here.
As we investigate the actions of IRS employees, I urge my colleagues to avoid making the investigation into a partisan attack.
Mentioned Cummings' earlier statement. At this point, this committee is not investigating wrongdoing for political purposes by high-ranking individuals in or out of this government. We are investigating something which has now been entered as fact, that wrongdoing occurred, and occurred over a group, and that group happened to be key-worded things that are generally called conservative. In my research,
Shulman, who was the head of the IRS when all of these actions occurred, was appointed by President Bush.
Mr. Shulman, you were appointed by President Bush when?
I was nominated in 2007, confirmed in 2008.
And you served until?
Committee, to the effect that from your looking into this matter, whether you call it an audit or an investigation, from your looking into this matter, you saw no evidence that IRS employees were politically motivated in their creation or use of the inappropriate screening criteria. Was that essentially your testimony?
That we received no evidence during the course of our audit to that effect, yes, sir.
All right, so...
The proper exercise of their right to explode themselves. Now, you've got a pie chart with 298. Is that 298 cases you looked at?
That is correct.
Now, if I'm reading this right, 72 of those were Tea Party, had the name Tea Party in them. Is that right?
That is correct.
And 11 had 912. Is that right?
That is correct.
13 had Patriots. Correct?
Correct, sir.
But 202 are listed as other. Were those all conservative groups, or could some of them have been progressive groups?
We were unable to make that determination, sir.
because in many instances the names were neutral and that you couldn't necessarily attribute it to one particular affiliation or another extent of it.
And I
Thank
know
you.
I have very limited
You
time.
testified yesterday that in conducting the audit, your office did not give further review to any of the more than 200 501c4 applications in your statistical sample and did not have Tea Party, 912, or Patriots in their title. Is that correct?
We looked, sir, I beg your indulgence. 202 non-Tea Party cases, so the various groups that you just enumerated, were reviewed for indications of significant political campaign intervention, which was our key criteria, again, in this exercise, in this review, Congressman. We did not evaluate whether or not they were conservative groups or progressive groups or liberal groups or whatever term you want to use, because those groups did not, again, have the be on the lookout terms, Tea Party, Patriot, or 912 in their names.
But then it is true.
The criteria used by the IRS Determination Unit in Cincinnati to identify tax-exempt applications for further review include specific organization names, such as Tea Party and Patriots, as well as policy positions such as government spending. In any case file, and this is what gets me, any case file statements that criticize how the country is being run. Anything that criticizes the government on how this country is being run, that was subject to enhanced investigation by the IRS.
The
Inspector General has also reported.
Thank you. I think it makes it clear. Oh, one more thing. There were 479 or so of these Tea Party groups that were targeted in total. Were there any BOLOs issued for progressive groups, liberal groups? Because I'm assuming that your investigation, we can't see them, but your investigation showed liberal groups that flew right through during the same time and got their 501c4s. They were not stopped. Isn't that correct?
Sir, this is a very important question. Please, I beg your indulgence.
Of course.
The only be on the lookout, that is BOLO, used to refer cases for political review were the ones that we described within our report. There were other BOLOs used for other purposes. For example, there were lookouts for indicators of known fraud schemes, so they could be referred to the group that handles those issues. For nationwide organizations, there were notes to refer state and local chapters to the same reviewers. As we continue our review of this matter, we have recently identified some other BOLOs that raise concerns about political factors. I can't get into more detail at this time as to the information that is there because it's still incomplete, that we've uncovered because it's still incomplete. And there are 6103 issues involved here, too.
So clearly it's fair to say, though, that
sir,
there
at this
was a
time,
BOLO.
but I certainly will.
I only ask if there's at least one. Are you aware of at least one that was targeted using a BOLO that was a 501c4 in which they were targeted politically but did not fall into this current report we have before us? I'm not asking for privileged information. I'm asking for one.
For the review, the purposes of the audit that we conducted, which was to determine whether they were looked for in the context of political campaign intervention, there were no others.
Thank you.
As I recognize the gentleman, there was a Fox News report today that the President's brother, I think, got his 501c4 approved in a matter of days, and we've got some conservative groups and possibly other groups that are waiting multiple years. Is there a standard?
Or if it was tone deaf, somebody trying to expedite a way to
you still don't know that this was political.
Excuse me?
You still don't know that this was political?
I'd defer to the Inspector General.
Well, I'll tell you this, Mr. Shulman. Your predecessor said that he wasn't sure if it was partisan, and that requires the listener to be as stupid as the speaker. to utter a comment like that. He just testified that policy positions dictated this. What does that mean to you? If it's not partisan, what does that mean?
I'm not sure I heard that testimony.
During the same period of time, well, at least two investigations were going on, one by the IG and one internal. Congress was misled. The American people were misled.
List of people being, after telling Congress that no one, absolutely no one is being targeted, you learn that there's a list of people being targeted. Tea Party, patriots, people who are critical of how the government is being run. And what did you do after that point? You did nothing. You did nothing to straighten out the impression that you had left by your testimony before Congress. Sir, you misled Congress. You misled Congress. Make no question about it. You told us one thing when you learned that our suspicions were true, when you learned that there was a list, you did nothing. You did nothing. You abdicated your responsibility, and you allowed Congress to proceed under your prior information that was false, that was untrue. And you never came back. You never notified Congress to say, sir, I gave you the wrong information. I misled you. You never came back to Congress to straighten out that impression. That's inexcusable. It really is.
And I said no targeting in the sense, and this, if you read the full testimony, that there's two ways for a social welfare group or a 501c4 to start operating.
Well, I'm not going to let you use up my time on that. Your answer was, the operative language was, there is absolutely no targeting. What was the basis for that statement?
So
obviously, you're the,
I can give you my explanation, and to the best of my recollection, what is in my mind, if you'd like me to.
Yeah.
So I said there was no targeting in the sense that there's two ways.
No, you said there's absolutely no targeting. It was more affirmative than that. What I'm getting at is you definitely gave Congress the impression that was absolutely no targeting. Absolutely.
To yourself, Mr. Shulman, in your failure to disclose information to Congress, I just feel that you've really violated the public trust, and it's troubling. Now, accept responsibility for your failure to correct the public record once you found out your testimony was not accurate?
I answered truthfully with the information I had, and I've said before, when I found out that a list existed, I did not have all the facts. At that time, the Inspector General was going to investigate, and I feel very comfortable that the actions I took were appropriate.
You are giving testimony. Your assurance, you could have said, I don't know. You could have said, it's outside the purview of this hearing, I haven't prepared, but you said, Mr. Chairman, there is absolutely no targeting. As you sit here today, you would say there absolutely was targeting, that this line of questioning was absolutely inappropriate at that time, and yet with 100% of these applications being approved in one office, the office that has these problems, you contacted no one there before making these assurances, not just to this Congress, not just to the chairman of the subcommittee, but to the American people. That's my concern. You called no one in that chain of command. You asked no one in that chain of command. I'm not saying you were lying. I'm saying you were derelict in inquiring about what the truth was.
On May 14th, the Treasury Inspector General released a report finding that the exempt organization's field office in Cincinnati, Ohio, used inappropriate criteria to identify for further review applications from organizations that plan to engage in political activity, which may mean that they did not qualify for tax exemption. On that same day, the
Department of those beliefs, to what do you attribute this, what seems to be kind of a rogue element in Cincinnati? It was told once to stop and ignored it or returned to this activity. Is it just a natural perversion in Cincinnati? Or I mean, what were they doing that they thought was proper, apparently?
It was, the conclusion that I can give you today, Congressman, is that it was a lack of oversight from management, both in Washington primarily, and the fact that they did not go back to ensure that the directions, the instructions that were given to the determinations unit within Cincinnati were being complied with. Once they found out that the initial inappropriate action had occurred, attempted to make corrective action and did direct a corrective action, they failed to go back to ensure, to follow up to make sure that those actions were being complied with. So it was mismanagement. It was a lack of fulfilling the responsibility that they have, sir.
Thank you very much, Mr. George.
As yesterday, this should have been brought up the chain earlier so that it could have been addressed. There was clearly a breakdown in this one unit of the IRS and of the chain that moved up, and I accept that this happened on my watch.
Okay, so you won't accept responsibility that
halt that behavior.
Yes. Thank you. But then the employee started slightly different, but still inappropriate practices a few months later?
Correct.
Okay. How were these employees allowed to resume these activities after management stopped them the first time?
That is the heart of the question, Congresswoman, which we still do not have a definitive answer to. My response, if at this stage, would be a lack of oversight, a lack of follow-up on the part of Ms. Lerner and people within her immediate chain of command. No one went back to make sure that what was being told to by them to do in Cincinnati was being done, and that's inexcusable.
Generated by my colleague from Oklahoma, as I'm standing holding in my hand as well a questionnaire for one of the organizations that made an application, but their application was made in 2009. It's now 2013, and they still have not gotten a response. And yet here we are, 39 questions that are being asked. This is the second level of questioning. Now, we hear some of this is all being done for efficiency purposes and other kinds of things, and yet we have people that have 39 questions that they're asking on subsequent organizations. So the issue I have for you is there an ability to have these questions resolved, as was stated by your successor, by a few people down in Cincinnati, or is there another level of questioning that these matters are vetted? Mr. Shulman.
I guess I understand your question, but
the testimony of Mr. Miller the other day, your successor, was that this matter was contained. It was at his specific language. This was the result contained by a couple of low-level employees in Cincinnati. This is where I'm having trouble really understanding where this is all coming from. And it was his testimony that it was a couple of low-level people in Cincinnati. And now I'm seeing 39 questions that are sophisticated and complicated. And the question becomes, is there somebody else beyond Cincinnati that's participating in the vetting of these questionnaires?
To the best of my understanding, I really don't know who approves all of the questions. It's pretty well outlined. I have made myself familiar with the IG report about requests for guidance and those kinds of things.
I'm not able to give.
Let me give you a little bit of information because I have from the application. Now, this is the attorney who has actually made the application, and this is the words of the attorney. Indeed, more than one agent in Cincinnati has advised me that the instructions regarding the processing of the Tea Party-related organization clients were coming from the Washington, D.C. office.
Yeah,
now, were there other levels beyond Pittsburgh, Cincinnati, as was testified by Mr. Shulman's successor?
That is still to be determined, sir.
Well, what ambiguity is there?
Apparently, again, the determinations unit on a number of occasions, obviously I don't know the instant matter you're discussing, had made requests to the technical unit in Washington for guidance on how to handle certain matters. The technical unit in Washington took
So you're saying that this was a request that was made from the floor?
Did I hear you refer to some of the behavior as gross mismanagement earlier in your testimony?
That is correct, Congressman.
And that was at the Cincinnati office?
That's correct, sir.
Would you have been referring to either or both Mrs. Paz and Mrs. Lerner?
I wasn't referring to any individual in particular, but I just want to actually revise what I just said. The gross mismanagement was not limited solely to Cincinnati. It extended to Washington.
Okay. Mr. Shulman.
Mr. George, you know, so far IRS would have us believe that this is a bunch of lower-level IRS employees who got around the water cooler one day in Cincinnati and said, who do we target this week? And they sort of got out of hand, and that's the end of the story. Do you think that's the end of the story?
I do not, Congressman.
You do not. And neither do the American people. What's disturbing, too,
before I describe Treasury's interactions with the IG related to this audit, it is important to underscore two critical points. First, there is no indication that Treasury was involved in the improper conduct at the IRS. The IG report did not find any evidence that Treasury or others outside the IRS had any role. Mr. George confirmed this point in his testimony before the Ways and Means Committee last Friday and before the Senate Finance Committee yesterday. Second, the improper conduct already had ended by the time Mr. George informed Treasury of the fact of his audit. Mr. George's report states that the improper conduct ended in May 2012. Mr. George has testified that he first notified Treasury of the fact that he was conducting an audit in June of 2012. It is important in this context to make clear that Treasury's longstanding practice, spanning Republican and Democratic administrations, is not to involve itself in the details of the IRS's administration and enforcement of the nation's tax laws. It is critical that the nation's tax laws are administered and enforced in a way that neither involves political influence nor the perception of political influence. This is particularly true with respect to decisions affecting specific taxpayers. Over the past 12 days, President Obama—
You know about the IG report. I don't want to know when you knew about the IG report. I want to know when you knew that the IRS was targeting people based on their political beliefs and their statements such as Tea Party or constitutionally directed organizations. When did you know what was happening in the IRS? Not when did you know what Mr. George was doing?
Congressman, I learned that when Lois Lerner made her public statement, and then subsequently a few days later when the Inspector General released his report. I did not know any of the findings or the details of the substance of what Mr. George looked into in his audit until then.
Mr. Shulman,
before yielding to Mr. Lynch, Mr. Woolen, just to follow up Mr. Turner's question, when did you learn of the internal investigation the IRS was conducting?
I learned through whatever testimony over the last few days. I hadn't heard of it before then.
So you didn't know about it earlier?
No.
This activity had stopped. Was that, and so you took no further action. Did you ever discuss this with anybody at the Department of Treasury, any Treasury official at all?
I had definitely had no substantive conversations with anyone at Treasury and did not report that that there was a list and that kind of things.
Mr. Woolen, when you learned that, Mr. Woolen, when you learned that this had gone on, who did you discuss this with at the department?
Well, I learned the details, Congressman, when the report was made public a week or 10 days ago, and obviously at the department at that point we discussed it with the Secretary and General Counsel and others to make sure that we began to put in place.
The Senate, where you testified that your audit did not uncover any evidence that the Treasury suggested the use of screening criteria or approved of the screening criteria that was used. Is that the case? Would you indicate whether you asked that question?
We did pose that question, Congresswoman, and again, the response was that there was no direction from the department itself to those in the determinations unit in Cincinnati, nor their affiliate office in Washington.
Well, I ask these questions because, Secretary, did you yourself ever suggest, or did you yourself ever propose that IRS personnel use screening criteria of any kind to target conservative organizations?
Absolutely not, Congresswoman.
Or other organizations?
Absolutely not, Congresswoman. Absolutely
Did
not,
you
Congresswoman.
order, indeed, did you approve the inappropriate screening criteria used by the IRS personnel in Cincinnati, Ohio?
I did not, Congresswoman.
Well, across your train of reference and responsibility earlier on, did you ever discuss congressional interest in the way the IRS was handling political nonprofits with the President?
I did not, Congressman, never.
Did you ever discuss it with anyone at the White House or any agency outside the IRS?
I did not, Congressman.
Why didn't you discuss this when you knew it was of such interest to Congress, and you knew Congress was apparently not satisfied with whatever actions the agency had taken thus far on either side of the issue?
Frankly, Congressman, the correspondence to which you referred did not come to me. I think it was in general, as you suggested, addressed to the IRS, and I frankly was unaware of this, of the concern until.
But Treasury has intense responsibility and ought to have intense scrutiny over the IRS, correct?
Well, Congressman, I think it's important for me to reiterate that with respect to the details of tax administration and tax enforcement, it's been the longstanding practice of Treasury departments spanning administrations of Republican and Democratic presidents not to get involved in those details, specifically because we don't want to have political influence over those kinds of detailed activities with respect to tax administration. I think this is a hearing and a subject matter that makes clear why that's not a good idea.
Not a good idea.
No, I understand. I'm just asking, did you have a conversation where you asked someone, is this true, is this happening? Because there were a lot of media reports before this came out.
I didn't. First I was aware of this, Congressman, was when the Inspector General came to me at some point in 2012 and said, on the basis of some congressional inquiries, he was going to begin an audit, and that was the first I learned of it.
Okay, so you didn't see any of the media reports over the group that you oversee?
I did not,
okay.
that I recall.
Wow. Mr. Shulman,
the gentleman is recognized.
In my office,
thanks so much. Thank you, Mr. Chairman. So, Mr. Woolen, do you have meetings with Mr. Shulman and his then deputy, Commissioner Miller? Did you do that on a fairly regular basis?
I had, Congressman, quarterly management review meetings where we looked at broad issues with respect to the budget and to how their IT refresh was going and so forth. Again, taking full cognizance of this relationship with the IRS where we didn't engage in discussions, didn't work in the details of tax administration or tax enforcement.
Right, but
just in the last few days.
Okay, so no. Okay,
right.
But were you informed? You were informed in June 2012 that the IG was undertaking their audit or review, right?
I'm not sure precisely, Congressman, when it was, but at some point, Mr. George came to me and said that he was undertaking an audit.
May, June, July, summer 2012.
Some point in 2012.
Some point in 2012. Was it perhaps before the first Tuesday after the first Monday in November? Just to establish as a fact here.
It may have been, Congressman. Okay. Again, I don't precisely recall when it was.
Mr.
And within the administration, there seemed to be a culture of insulation that puts higher priority on deniability than addressing blatant wrongdoing. The American people don't expect.
Thank you, Mr. Chair. Rogue agents. That's what the White House tells us were the people responsible for this. In fact, I got a news report from May 15th that says, White House aides, 2 rogue IRS employees from Cincinnati were responsible for investigating conservative groups. 2 employees in Cincinnati responsible for the systematic targeting of conservative groups for over 2 years. This administration would have us believe that. This administration, this agency, the very agency charged with enforcing Obamacare, systematically targeted groups who came into existence because they opposed Obamacare, and they started the targeting the very month, March 2010, that Obamacare became law, expects us to believe it was just the work of 2 rogue agents. This administration,
very unfortunate.
this agency.
I want to ask you about 2 major issues.
First, I'd like you to address the allegation that the administration was engaged in some kind of effort to use the IRS to target its political enemies. So I want to walk through this very quickly with you. Who nominated you to be the head of IRS?
President Bush.
Are you biased against conservative groups?
No.
Do you think they deserve more scrutiny than liberal or progressive groups?
No.
Did you ever order IRS employees to target conservative groups?
No.
Did you ever encourage or prompt them to do so in any way?
No.
Did you ever receive instructions from anyone at Treasury to target conservative groups?
No.
Did you ever receive instructions from anyone at the White House to target conservative groups?
No.
So these misguided actions, Mr. Shulman, were initiated by IRS employees. They were not part of any administration conspiracy, and you had no knowledge of them before 2012. Is that right?
I personally don't remember ever hearing about this until the spring of 2012.
Now,
there was outside influence outside IRS. And did you find any evidence that anyone in the White House in particular suggested that the IRS target conservative organizations, or that they played any role whatsoever in selecting the criteria?
No, Mrs. Congresswoman, but in all honesty, we didn't look at the White House. We didn't question anyone as to whether or not they'd received any direction from the White House. And
Now, that specific question was not asked.
That's correct.
Now, in the investigation which continues.
Excuse me?
You ever talk to anyone at the White House about this issue?
About this issue? Not that I remember.
You ever go to the White House? Time as Commissioner, did you ever go to the White House for meetings?
George, for your testimony, Mr. Shulman, and thank you, Mr. Chairman.
Thank you. Mr. Shulman, real quick follow-up. The 118 times you're in the White House in 2010, 2011, who were you meeting with?
First of all, I'm not familiar with that.
Straight from the White House log.
And I'm assuming that it counts when I go to OMB, which is, the budget office for resources, et cetera.
No, it counts when you go to the White House. That's what it was. The times you've been at the White House, that's when it counts. So who'd you meet with? Was pretty important. You talked about it a lot.
The IRS has a major role in the money flows of
Exactly.
the Affordable Care Act.
Exactly. And you started targeting the very groups who came into existence because they opposed what you were talking about in the White House, 118 different visits there. You started targeting them the very month that the Affordable Care Act became law. And yet you didn't have any conversations about the subject matter at hand today on those 118 visits, when many of those visits were about implementation of the Affordable Care Act, and the groups you were targeting were opposed to the Affordable Care Act. That's a question.
I'm sorry, what is the question?
You went to the White House 118 times. One of the key subjects you talked about was the implementation and enforcement of the Affordable Care Act. Going on in your administration, at the time you're as commissioner, targeting of groups who came into existence because they opposed the Affordable Care Act, and you never brought it up in any of those conversations and all those visits to the White House when this was a major topic of conversation.
No, I did not.
Okay.
I
That's all I wanted to
operated
know.
as a nonpartisan, non-political person trying to implement the laws that were on the books. It would have been inappropriate, and nobody ever asked me, nor did I ever.
That would all be well and good, Mr. Shulman, but Mr. George issued a report that said just the opposite. That's the whole point. That's why we're here. And you said you could give assurances that it wasn't happening. Mr. George issued a report that said it was, and you were at the White House 118 times talking about
Stipulate for the record broadly, if there are more questions about
Did
that.
you ever talk about 501c4s at the White House?
About
no?
our either determinations process or
Anything about 501c4s? Did you ever talk about the Citizens United case?
Not that I remember.
You never had a discussion?
Not that I remember.
No discussion about 501c4s?
Not that I remember.
It was a major thing. It is a big deal. You never had one conversation.
Not that I remember.
You said you first heard about this problem in spring of 2012,
About 42
correct?
over that course of time. I also look at a train of events, September 2010, Senate Finance Committee Chairman Baucus wrote a letter to the IRS asking the IRS to survey tax-exempt organizations to ensure that political campaign activity is not the organization's primary activity. October 2010, Senator Durbin wrote to the IRS to review the purposes and activities of several tax-exempt organizations. February 2012, Senators Bennett, Franken, Merkley, Schumer, Shaheen, Udall, and Whitehouse wrote to the IRS about the issue. 32 Democrats in March of 2012, House Democrats wrote to the IRS and the White House to ask that political activity of tax-exempt organizations be investigated. July and August of 2012, Senator Levin sent letters to the IRS and said that the IRS appears to be passively standing by while organizations clearly ignore the tax code with no apparent consequences. Now, this to me seems like a significant amount of requests for information and concerns that private citizens, organizations seeking tax-exempt status who happen to be of the conservative side would be checked on and questioned. Now, I find it difficult, Mr. Woolen, to understand how that didn't come across your train of reference and responsibility earlier on. Did you ever discuss congressional interest in the way the IRS was handling political nonprofits with the President?
I did not, Congressman, never.
Just about accountability. And all the scandals, we hear the same thing from time after time by the government officials that are involved. Benghazi, IRS, AP reporters, Fast and Furious. Time after time we're hearing people, wasn't my job, I don't know, it was the other office, I was recused. I didn't find out about it until you found out about it. Where does the accountability begin? People's lives are on the line in these things overseas. People's constitutional rights are at stake here. Where does the accountability begin? I'll close with one comment.
Never.
Did you ever discuss it with anyone at the White House or any agency outside the IRS?
I did not, Congressman.
Why didn't you discuss
that this was going to be a report that was going to reach a very damning conclusion, but I didn't have any understanding.
Did you give a heads up to the White House Chief of Staff?
I did not.
Okay. Thank you, Mr. Chairman. Thanks for your indulgence. The absurdity of this is that when a huge accusation is being undertaken by an Inspector General in a presidential year, it is beyond me to think that an administration official wouldn't have maybe. Let me ask another question. Did you contact Chicago about it?
The gentleman's time has expired. Make it very quick.
Did you contact the campaign about it?
I never had any contact with the campaign.
Okay, just to make sure. Thank you.
Mr. George, just for the record, I assume in response to Mr. Again, the same is true. Today you may not be able to speak to intervention that came from above or any other place, but you can't rule out that there was some at some time.
That is correct, sir.
Thank you. We now go to the gentlelady from Illinois, Ms. Kelly.
Shulman?
Could you repeat the question?
Yes. Were you flooded with resources after Citizens United to deal with the volume that the inspector...
Were we given resources?
Yes.
No.
No.
Things to clarify, because it made a very good point, this doubling. Isn't it true that they began targeting Tea Party before there was any doubling, that your own testimony shows between 2009 and 2010 there was not a marked increase, and they began targeting with just one Tea Party application and then expanded it?
They did, yes, sir.
Thank you. I think that makes
Mr. Sponsor, in response to Mr. Cartwright, you said something I don't think you're competent to say, and that is when looking at your own report that showed the doubling of applications for 501c4s, you said, well, that's just coincidental to Citizens United. You don't know that. We don't know if it's causal or coincidental based on your analysis, and I wanted to give you an opportunity to acknowledge that.
I agree with your statement, but my point was that we did not indicate in our report
I understand.
that because of Citizens United there was a doubling.
I understand. And
I just, Mr. George, following up on Mr. Pocan, just one quick thing. I had our staff check, and Citizens United was decided and announced on 21 January 2010, and the IRS began targeting Tea Party groups in March of 2010. Isn't that correct?
I'm not sure of the date of the...
But the first file pulled, according to Ms. Paz, would have been that less than 2 months later.
Well, I'm not sure of the date of the issuance of the Supreme Court.
Oh, no, we can all get that at Google.
Right.
That's a fact online. But essentially, if there's a coincidence, the IRS began targeting in less than 60 days Tea Party groups after Citizens United was started. I would assume that it's awful hard to have this supposed exponential increase in applications in less than 60 days, especially since they had gathered starting with application 1. Isn't that essentially, without exceeding what Mr. Connolly would agree to, if there's a coincidence, isn't that the coincidence that it happened so close to the deciding of a Supreme Court case, not to the increase in applications?
It does seem coincidental, sir.
Thank you. With that, we go to the gentleman from Arizona.
My best understanding, though, is that people were operating at that time, and there's also, my best understanding is there's a whole other option for someone to be a 501c4.
Did you know, Mr. Miller?
They don't need to apply.
Did you know, Mr. Miller?
Okay. So I said there was no targeting in the sense that a 501c4 had 2 options to operate. They could apply, or they could start operating. There's no need to go through this application process. You can be a 501c4, do your business, and file a tax return at the end of the year.
About there.
My best understanding is that none of these groups, of the 300 that are talked about, or the 298 in the report, actually have to apply for 501c4 status, that a 501c4 can start operating, can hold itself out, can do all of its business, and then can file what's called a Form 990, which is the equivalent of a tax return for a tax-exempt organization. So I think that's an option that organizations have.
Mr. Shulman, do you consider yourself a good leader?
Excuse me?
Do you consider yourself a good leader?
I do.
Okay, so
is completed. Shulman, I will admonish you, as best I can as one member of government to a former member of government, that in fact there was a there. People in your own internal operation knew. If you didn't know, you were derelict in your duty, or your management style was such that you didn't get informed. Either way, that is certainly not something you should be proud of. To the extent that you, so it's your testimony that, in fact, independent of your activity, Mr. Shulman's reports conducted and concluded wrongdoing and could have, in fact, reported that up the chain and taken appropriate action independent of your activities.
That is certainly an option, sir.
So, Mr. Shulman, before I go back to Mr. George, it was your watch. Your people did an internal review. How is it you did not know that things were rotten in your shop in time to not only make sure it stopped and stayed stopped, but in fact the Treasury, your boss sitting next to you, was aware of it?
You know, I've said that I learned about this sometime in the spring, and by this I mean I learned the fact that there was a list and the fact that Tea Party was on it.
Okay, so you knew at that time that you had mistreated Americans within your organization and saw no need to report it up the chain. Is that your testimony?
My testimony is that at that point, I had had a preliminary verbal report. I had been told at that same point that the activity was being stopped, and I was told that the IG was looking into me to apply.
Did you know, or Miller, or had sent, or had you sent, approved of sending Ms. Lerner down to look at this?
Mr. Miller informed me sometime in the spring that he was going to look into the matter further and find out what was going on down in the
But did you know Ms. Lerner was doing it?
My interactions on this were directly with my deputy.
All right. You know how many?
I do not.
We got some information from you all yesterday, a list of correspondence regarding 501c4s, and we counted them up. 132 different members of Congress contacted you over the appropriate time period. Did you read any of those letters?
The letters that I remember about this set of facts around
did you read any of them?
General started coming in February of 2012.
Well, this is from the IRS. Major news stories. So here's what everyone wants to know. You got 132 members of the United States Congress contacting you about this issue, 42 major news stories about this issue in the time period in question, and you never checked it out. You never researched it. I mean, are you sure you're being square with us today, Mr. Shulman?
I'm absolutely telling you the truth today.
Absolutely. Well, that's interesting because Mr. Lynn,
you first heard about this problem in spring of 2012, correct?
I heard that I first heard about the BOLO list in spring 2012.
When did you first hear that there was a concern about the targeting of based on political beliefs and political speech? When did you first hear that?
To the best of my recollection, it was in the February-March timeframe of 2012.
Okay, no, you can't. On June 3rd, 2011, the chairman of the Ways and Means Committee, Dave Camp, sent you a letter. June of 2011, second paragraph. Now, without no warning, the IRS appears to have selectively targeted certain taxpayers who are engaged in political speech. And he goes on. How is it that he, the chairman of Ways and Means, sends you, the head of the IRS, a letter like this, and you say you know nothing about it?
So that's where I was going to go. This is a very separate matter.
No, you weren't.
This is a very separate matter. That's a gift tax matter that I'm aware of. About 8 months.
All right, 4 years and 8 months. You get 132 letters from members of Congress concerned about targeting, and you send them to Ledge Affairs to deal with. Did you feel any responsibility to go to the Cincinnati office and find out for yourself what was going on? Did you ever make a visit to the Cincinnati office?
I guess I don't accept the premise that I got 132 letters about targeting. I certainly wasn't aware of that number till now. I knew about 2 questions.
Well, regardless, when Congress contacts you, whether it's 12 senators or members of this committee, I mean, doesn't it alert you to the fact that, you know, maybe if there's smoke, maybe there's fire? So did you ever visit the Cincinnati office?
I visited early in my tenure the Cincinnati office, which has many different operations, but I don't believe I went to Cincinnati during this 2012 time.
Do you take responsibility for what?
Take responsibility for the list?
Yes.
Being done? I don't take personal responsibility for there being a list with criteria put on it, but I do accept the fact that this did happen on my watch.
So you, as far as duty as I'm concerned, to find out what was going on in the Cincinnati office when members of Congress, 132 of them or 50 of them or 10 of them, inform you that they think that there's some kind of targeting going on. And if that doesn't elevate your concern and interest, then something's fundamentally wrong between the way Congress interacts with the administration and the bureaucracy.
That's not a good idea.
Not a good idea. Shulman, when did you learn about the second BOLO again and the failure of employees to follow explicit directions from their superiors?
About the fact that there was a BOLO and then a second BOLO and that employees hadn't followed directions?
Yes.
That I didn't learn about until this last week when the report came out.
But it should have alerted you because, I mean, as a head person with these big things happening, you should have followed up. Beauty's in the detail. I've watched you all day. You're really good at certain parts of detail, and then you obscure the rest. I mean, there's a disease going in America. I see it in trials all over the country. We feign because somebody gets in our face that we don't acknowledge something. I want to go further. Are you aware that in July 2012, Senator Harry Reid claimed Mitt Romney hadn't paid taxes for the last 10 years and claimed to have the information supporting that? Are you aware of that? I'm sure you are.
I have a recollection of reading that in the paper.
Do you know how Mr. Reid obtained that information? Did you look into this?
I have no idea how.
Doesn't that alarm you that all of a sudden this pertinent information comes up, you're the head of this agency, and you're not asking questions? Shame on you. Absolutely shame on you.
Taken by all of the lines in the report.
Well, I am deeply disappointed in your answer because right now, in forward operating bases in Afghanistan, all over the world, we have 25-year-old buck sergeants and second lieutenants who know you can delegate authority, you can never delegate responsibility, and that you're always responsible for the performance, the training, the actions of the men and women under you. And I hope that you remember that in the next position you go to. Thank you, Mr. Chairman.
Gentlelady would yield.
Chairman, when you learned that conservative groups were being targeted by the IRS for discriminatory treatment, what did you do?
When I learned of the existence of a BOLO list, in that same conversation or right around that time, I also learned a couple things. One, that it was being stopped. So that
all right, and who told you it was being stopped?
That's Steve Miller, my deputy.
All right, and did you investigate further? Can you give me the name of a single person who was involved in the original decision to target conservative groups for disparate treatment?
I'm not aware of those names.
Why can't you give me a name?
So at the same time that I learned and that it was being stopped, I was also told that the Inspector General was aware of it.
Mr. Shulman, is the Inspector General the only person who can investigate wrongdoing within the IRS?
My general practice.
Can you answer my question and then you can explain? Is the Inspector General the only entity who can investigate wrongdoing?
Congress can investigate.
How about you? Can you do it?
The practice at the Internal Revenue Service that I inherited.
So if there's inappropriate conduct being done on your watch in the IRS, then that inappropriate conduct can last as long as the Inspector General's investigation lasts. Is that what you're telling me? That you're not going to step in and stop it?
No, what I'm telling you.
If there's someone wielding a knife in the parking lot, are you going to call the Inspector General? Are you going to wait until his or her investigation's over before you stop it?
When I was told about these allegations, I was also told that they were being stopped, and so that the inappropriate criteria were not being used
anymore. And despite the seriousness and potential criminality of that conduct, you didn't investigate it yourself at all?
So the procedures that I inherited and that my
Mr.
general
Shulman,
practice
this is going to go much quicker if you'll answer yes or no, and then you can explain. Did you do anything to verify that the practice, as insidious as it was stopped?
The Inspector General was going to be looking into it, and that's what.
Is it that you can't say yes or no, or you're just choosing not to say yes or no? Can you answer the question, did you do anything personally to make sure that this insidious, discriminatory practice was stopped? Yes or no?
At the time that I learned about it, I also learned two things. The first was that it was being stopped, and the second was that the Inspector
And what did you do to verify that it was stopped?
The responsible deputy of the Internal Revenue Service told me it was being stopped. I had no reason to believe otherwise.
Did you investigate why conservative groups were being targeted?
Excuse me?
Did you investigate? So you can't give me a single name. You can't answer the who. Can you tell me the why? Why were conservative groups? Why was the culture such under your watch that an employee felt comfortable targeting conservative groups? Did you investigate that?
You know, from my reading of the report, I can't tell if it was political motivation or if it was tone deaf, somebody trying to expedite a way to
You still don't know that this was political.
Excuse me?
You still don't know that this was political?
I'd defer to the Inspector General.
Well, I'll tell you this, Mr. Shulman. Your predecessor said that he wasn't sure if it was partisan, and that requires the listener to be as stupid as the speaker to utter a comment like that. He just testified that policy positions dictated this. What does that mean to you? If it's not partisan, what does that mean?
I'm not sure I heard that testimony.
Well, we'll be sure and get you a copy of the transcript, and you can supplement your testimony. How's that? Do you agree
I'd be
with
happy to
Dan
answer the
Pfeiffer?
committee's questions.
Do you agree with Dan Pfeiffer that the law is irrelevant, or do you think it is relevant?
I think the law is always relevant.
Do you think 26 U.S.C. 7214, which provides for criminal penalties for this conduct, would be relevant? And did you refer the matter to someone with law enforcement investigative jurisdiction?
I'm not going to speculate what's appropriate legally in this matter, and Mr. George, I knew his operation was looking at it, I believe.
I thought it was an audit. I thought he just testified it was an audit, not an investigation. Did you refer it for criminal investigation?
I didn't refer it. It was already being looked into at the time that it was brought to my attention.
So I want to be real clear because my time is out. The only recourse you have when there's an allegation of wrongful conduct on your watch, the only thing you feel comfortable doing is waiting on an inspector general to finish his or her report.
The general practice is to make sure the inspector general will look into it.
No matter how insidious the conduct. If it were an allegation of racial discrimination, you would have waited until Mr. George finished his investigation? Is that your testimony?
I'm really not going to answer hypotheticals.
I tell you what, instead of answering a hypothetical, why don't you answer the case at bar today? If there's an allegation that groups are being discriminated against based on political ideology, are you really going to wait until an inspector general finishes his or her report before you take corrective remedial action?
When I have a fact, but I don't have all the facts, and I don't know the scope and severity.
Did you investigate the facts, Mr. Shulman? Did you lift a finger to identify the facts?
Felt very comfortable. The facts, the inspector general was going to run down the facts, and once he had it, it would be reported out.
Let the record reflect that's a no.
As a good leader, that was enough for you.
Excuse me?
As a good leader, that was good enough for you.
I feel very comfortable with my actions.
Wow. Okay.